Law is a set of rules or principles that control human conduct, thereby helping in the administration of justice. A rudimentary definition of law within Uganda's legal system is a rule that is backed by a sanction for its breach, ultimately enforceable by a court, a tribunal, or arbitration. Sanctions for breach of law takes many forms, i.e., a sentence is passed for breach of a criminal law, compensation, damages are awarded, or restitution is ordered for breach of civil law. What we can notice from the definition are the following. 1. Set of rules. Law is a set or body of rules. These rules may originate from customs, acts of parliament, court cases, or some other acceptable sources. 2. Guidance of human conduct. These rules are enforced for the guidance of human conduct. Human beings follow these rules for their own safeguard and betterment. 3. Applicable to a community. The rules apply to a specific community. This community may be a sovereign state or a business community. The laws of different communities may be different, e.g., what the law in Kenya may not be the law in Uganda or Tanzania. 4. Change of rules. The law changes over a period of time. It means law is not a static phenomenon. It keeps changing with time. i.e., what was law in Uganda in the 1960s may not be law in the 1990s. 5. Enforcement. The law must be enforced. Otherwise, there would be anarchy. The law enforcing agencies include police and courts of law. Law is divided into criminal law and civil law. Criminal law governs or regulates the relationship between the state and individuals. This branch of the law creates crimes such as murder, theft, rape, assault, etc., and they are primarily provided for under the Penal Code, although they may be prescribed in other laws such as the Traffic and Road Safety Act. Crime is a public wrong, and if one commits a crime, he commits it against the state, and the state, through court, intervenes to punish the offender. Civil law, on the other hand, governs or regulates the relationship between persons. For example, where one causes an accident due to reckless driving and which results into death of another, this is a civil wrong called negligence under the law of tort. Besides the law of tort, other civil laws include the law of contract, which is divided into several other specific laws such as the law of sale of goods, agency, insurance, banking, etc. It should, however, be noted that there is a considerable overlap between non-legal rules and the law. For example, the basic rules of most major religions are astonishingly similar. Most of them condemn murder, and so do all legal systems, although what constitutes murder and the punishment imposed differ from one legal system to another. Nevertheless, many forms of antisocial behavior, such as spitting in a crowded street, would shock most people as a breach of the rules of civilized behavior, but are not illegal. A distinction must also be made between the immoral and the illegal. Law, therefore, is a formal mechanism for maintaining social order. Importance of law. Rules of law facilitate administration of justice and promote cohesion in the society. Law is an instrument used by human beings to achieve justice in society. Law helps in the maintenance of peace and order by promoting peaceful coexistence and prevents anarchy through punishing offenders and providing remedies to aggrieved parties. Promotes good governance in society, provides protection of rights and duties. Reduces incidences of revenge by ascertaining whether or not a crime was committed. Civil laws protect individual rights and enforcement of duties.